Hi everyone, I am Ian and this is Spafa Sesh. This is Spafa Sesh. This is Spafa Sesh. Spafa Sesh. Are we on?
Yes,
Okay. The Sesh is a SEAMEO Spafa online series initiated in 2020. It features knowledge sharing and discussions on the arts, archaeology, and heritage conservation in the region. For those who are merging with us in SESH for the first time, SEAMEO SPAFA is one of the regional centers of the Southeast Asian Ministers of Education Organization, SEAMEO. We focus on archaeology and fine arts in Southeast Asia and organize activities such as training courses, conferences, and workshops. We are delighted to present today's program from copyright to Creative Commons with a disclaimer. This discussion is about learning some new things that we didn't know before. However, it is not a legal consultation. General information will be discussed, but for specific issues of questions of law that you encounter or will encounter, you should seek proper legal advice. Nevertheless, we do count on you to gain a better understanding of copyright and Creative Commons licensing and learn a thing or two about the selection, use, and sharing of multimedia content, especially on the internet. Our discussion is expected to take about more or less an hour and a half, starting with basic information on copyright and Creative Commons licensing through to some common misconceptions. We will try to keep the conversation casual so as to engage you, the audience, as the subject matters can be rather complicated, especially copyright. Great. With that out of the way, I am psyched that joining us for this conversation are two engaging guests and my co-host, Lin Ant. Please, Lin Ant.
Thank you very much, Ian, for introducing SEAMEO SPAFA and what we're trying to accomplish through SPAFA Sesh. So as Ian said, we organize these online discussions, and this one is to increase awareness in the knowledge and understanding of Creative Commons licensing and copyright as part of our efforts to promote ethical integrity, mutual respect, and excellent practice in our work. So good morning to our viewers, and thank you for following us live on Facebook and on Zoom. Feel free to drop in a question on the Q&A function on Zoom or to put it in as a comment on Facebook, and we'll try to address it as we go along. So first off, I'd like to introduce one of our panelists with us today. We have Susanna Tamtemsal, who's working towards changing lives for the better through art and culture. She is the founder and executive director of Creative Migration and Bangkok 1899, which promotes cultural diplomacy through art, public engagement, and sustainability. Susanna believes in protecting the rights of content creators and has been using Creative Commons licensing for over a decade.
And our other guest is Tereen Charanport, intellectual property lawyer of more than 20 years experience. His work with leading law firms, the government sector, and startup companies. Tereen loves reading and exploring outstanding restaurants in Bangkok, a hardcore foodie. Tereen, with the technology today, we have a copy and paste culture that offers us a diversity of images and tags and content at our fingertips. Click here, click there to use and distribute. This very convenience causes us to lose appreciation for the legal and ethical implications of using other creators' works. So on the points of what content on the internet we can and cannot use without permission, we can benefit from understanding some copyright basics first, and then find out more about how to share our work with the wider community to increase creativity. Now, turning to Terin, our pundit for the day, what is copyright and what can be protected under copyright? Terin?
Thank you so much, Ian. And you rightly said that in this days and age, it's very convenient to just copy and paste. But and I know that a lot of people think that if things is on the internet is free, because what else? Why people put it on the internet? But that might be incorrect, and that might land you into big trouble later on. I have a friend who is a website designer, startup actually, and then he just felt that way, that you can take anything out of the internet and use it for free. And granted that it might be hard to know who owns what on the internet, especially on the picture side. My friend surprisingly got a notice from the owner in the United States. My friend is in Thailand, so he's pretty surprised that he got that kind of notice from other country asking him to pay quite substantial compensation for the use of the photo that he used. So I think it would be very important for people to know what is copyright, what is intellectual property in general, how to use it legally, and how to protect it if you are the creator of the work. So for that, before we dive into the discussion, I have a short PowerPoint just to give the audience some ideas on what it is. Let me try showing it 1 second. Oops. All right. Okay. Let's start. So before we go, I know that today we're going to talk about copyright and Creative Commons. And before we go into that, I want to give the audience the basic understanding that when we talk about copyright is part of intellectual property, but it's not the only intellectual property. And for one work, it might comprise of several intellectual property. For example, I know that everybody have a smartphone right now. So if you look at this iPhone, by the way, I took this I take this photo from the legal website that allow them to use the picture. Just a disclaimer. So if you look at the iPhone, you will some people might not know that there's several intellectual property in just one iPhone. For example, if you look at the Apple logo, that is protected under trademark, not copyright. So we're going to talk later on what trademark is protected briefly. And if you look at the shape of the iPhone, it considered to be industrial property. And in many countries, like in Thailand, that's protected under the patent law. And the microchip and everything, those can be protected under patent law also. On the application, the software, that is protected under copyright. So you can see that in just one product, there's several intellectual property at work. And if you want to use it, or if you are the creator of the work, you may want to know that what kind of intellectual property protect what. Because there's different type of protection, different term of protection. So you might need to know that. And the R&D, the research, the marketing plan, that can be protected under the trade secret law. So that's another type of protection. Just to give you guys the idea that in one product, there's so many protection under the intellectual property system. So now going to our discussion today on the copyright. What is copyright? In short, it's a legal protection for the authors of the original work of authorship. So I'm stressing on the original because it's not, when you create something, not everything in the whole world will be protected under copyright. It needs to be the type of work that is listed here. I have to say that in general, copyright protection is very similar in all the countries. That is part of the World Trade Organization, because if your country is under the, is a party, is a member of the World Trade Organization, then you are required to have a certain level of protection. So that makes it very similar in each country. However, the actual language in the law might be different. So in general, the copyright work is protected for literary work, just like books, newspaper. Musical work is like musical notation of any kind, dramatic work, it's like the
Compositions.
Yeah, plays, TV show, pantomime, and choreographic works. In some countries, that is a part of dramatic works in the law when they say it. Picture graphic, that's also part of copyright protection, motion picture, sound recording, even architectural works can be protected under the copyright. But you have to understand that copyright protection extends only to the expression, not the idea itself. So if you have a very great idea, very original, but you not express it in some way, in some of the country, like in the United States, they require what we call a fixation. So your idea must be fixed in some kind of medium in order to get the copyright protection. However, in some of the country, for example, I'm living in Thailand. In Thailand, fixation is not required by the law. So as long as you create it in some way, then you get automatic protection. That said,
Meaning the idea is not copyrighted, but the expression in
Yes.
material form.
Yes. But even without fixation, I mean, some of the countries, ASEAN country, we not require fixation for the copyright work to be protected. But if you not fix it in any form, it would be hard to prove later on in court if the dispute rise. So it's still, yeah, in practical way, it's good to write it down and even record it with the IP or Copyright Office. You have to understand that when people think of intellectual property or copyright, they think that it needs to be registered. That is not entirely true. Like I said, it's protect automatically once you created it, you expressed it. But in countries like, for example, in Thailand, we have a recordation system where you can record your copyrighted work with the IP office. And then it will be used as an evidence later on if the dispute arises. It is not, since it's a recordation, there's no examination process, so it's just recorded. So it will be used as evidence, not the clear-cut proof that you are the copyright owner. So, for example, if I'm recorded it, eventually I will still have to prove it, but it will be used as one of the major evidence. If the other person who dispute with me don't have any claim at all, then I have some evidence, then I have a better chance to win in the court. So just so you know that there's some recordation system there, but it's not required for your work to be protected. Okay, I'm gonna go back to copyright later on to talk to detail, but I'm just want to touch base on the other type of intellectual property, just so you know what they are. So the other very common intellectual property that you might know is trademark. What is trademark? Trademark is a word, phrase, symbol, design, combination, or even, especially in the United States, just the single colors or even the smell can be protected as a trademark. However, in order for the name or the words to be protected as a trademark, the key point is that it needs to be a source indicator. It needs to be linked with a certain type of product or service. So if you use this particular words with particular product or service, that can be considered as a trademark. However, unlike copyright, most of the countries in the world require trademark to be registered to get the full protection as a trademark. And when you register your trademark, it will protect your trademark in that particular country. I got a lot of clients say that, well, I have this trademark in the US. I found that this company in Thailand are using my trademark and I want to sue them. But if that company in the US is not registered that particular trademark in Thailand, they have very limited protection. And in worst case scenario, if someone else registered the trademark in that particular country before your trademark register, then you are not owning that trademark and they can sue you if you bring in your product into that particular country. So need to be aware. And like I said, I don't know whether you see the example on the right side, the Google, I mean, the name doesn't need to mean anything. It can be fanciful. Actually, it is better to be fanciful because if you use just a common general name, then it cannot be used as a trademark. It can be the name of the person, channel. It can be just a sign without any words on it, like this one. If people can know what this means, what this logo belong to, then it is usable as a trademark. You know on what this means, who's owned this logo on the third one? Who owns it? Please.
Nike, right?
Yep. All right. And even the packaging, the lot can be used as a trademark also, if you know what this belong to. So, Lina, you know the last one, what companies belong to?
Hershey's.
Good. All right. Okay. Now we can move on from trademark. So that's unless. But if anyone has any question in anything that I said, you can just jump right in. All right. The other type of common intellectual property is patent. Patent is an exclusive right granted to an inventor to avoid invention, is a product or process. And in general, in most of the country, it fit into two types of protection: utility patent, someone who invents or discovers any new and useful process, machine, article, and it need to be, let's say in Thailand, it's also need to be able to use it in industrial way. You should be able to mass produce it. The other type of protection is a design patent for granted to anyone who invents a new, original, and ornamental design of the article of manufacture. So generally, this is what patent is protect.
Oh, and for the designs,
yes.
For the patents, usually if you want protection, we will need to register the patent.
That's correct.
Yeah.
And each IP protection has a different term. For copyright, I'm going to talk later on, but for copyright is normally it's 50 years after the author is dead. But for trademark, it's 10 years after it has been granted, and you can renew it as long as you not forget to renew it, and it will continue to have protection.
Right.
For patent, it's generally 20 years after the filing date, not the granting date. So let's say you file 10 years before, and you just has been granted today, the protection will retroactively go back to the filing date, not just from today. So you need to know that. And for patent, is also protect territorially, so it protect in the country that you registered.
Thank you.
Yeah.
Thank you, Terry.
For the copyright protection, is the copyright, like I said, is the the law protect the original idea, expression of idea, and the copyright owner will have the exclusive right to reproduce, making copies, to prepare derivative work, to change it from, let's say, one form to the other form, from books to movie, for example, and the right to distribute that work, and the right to perform or display the copyrighted work publicly. And copyright owner also have the right to authorize others to exercise these exclusive rights on their behalf. So if you are doing something that is falls under the exclusive right of the copyright owner, you need to get the permission, unless they fall under fair use, which we can discuss it later on in the discussion. Okay. I think I'm going to stop here and then make it a more discussion style. I know PowerPoint is very boring, so I'm just going to turn back to you, Ian and Lina.
Yeah, so thank you so much, Tieran, for giving us an overview. I think it's definitely important for people to understand what the difference is between an original work and all of that. If you could just maybe tell us what the copyright symbol means, the C with the circle around it.
Okay.
Yeah, thank you.
Sure. Yeah, C in the circle, we saw that a lot, didn't we? It's actually it's a copyright notice, which is I think it's originated in the US, and in the old days, it is required to have this copyright notice for the copyright to be protected. But under one of the international treaty, the Berne Convention, that provide general rule guidance for copyright protection, they said it's not required anymore. So yeah, for most of the country that is part of the Berne Convention, you can put it in to say that this is copyrighted work. It doesn't have any legal impact whether you put it or not. The work will be protected automatically once you express it. So yeah.
Thank you so much. And you talked about trademarks and patents being needing to be registered. What about copyrighted works? Do
yes.
These need to be registered?
Copyrighted work, you do not need to be registered. So once you created it, then you have protection. And like I previously mentioned briefly, in some of the country, you require to have some type of fixation to fix it in some medium form. So let's say you draw it on the paper, that's fixation. So you will get protection. However, one of the things that need to be considered is the originality level of the work that you created. This is different in each jurisdiction. So in general, the law will require that you have to have a certain, in Thailand, we use the word which means that you need to put an effort to a certain level of effort. Doesn't need to be very high efforts, but it needs to be something. So if you just put in just one word, that might not be enough originality. And the other part of originality is that, like you said, you need to be original. You cannot copy others' work. So once you have to meet the level of originality and then you express it, you get protection automatically. You do not need to register your work, at least in ASEAN country. But like I said, you do have a recordation system where you can do it. And in some of the country, if you record it, then you have a better right. For example, you may be able to claim more damages if you register it. So it will be useful when you enforce your right. It doesn't need to be registered to get protection.
Thank you so much, Tieran. And before we continue with the discussion questions, now that we have some more viewers joining us from across the world, I'd like to take this opportunity to say that those who post a question or comment on Zoom and on Facebook get to win a SEAMEO Spot Hub bag. So please keep the questions coming. Thank you.
Susanna, I know that you are a keen photographer, so you should be the copyright owner of plenty of resources. And as a copyright owner of a creation, how can I allow others to use my creation? What does it mean to license my creations?
So yes, this is a complicated, as we've been going over, situation in terms of what you put out in the world and how people could use it, and also how much, if somebody takes your work, how much you're going to pursue it. So there's a balance, right? And so I think the first sort of thing that I think about is not being so precious with what I'm making, because when you put something out into the world, it's going to be interpreted and possibly used in many different ways. And so that's sort of like at least mentally, that's how I began, right? And then, because you want to just put it out into the world so that people see it as well. And there are all the pitfalls that can happen, but at least I feel like as a content creator myself, the more I generate and the more I stay active, the more I put out into the world, the more originality comes out of me. So just like in a more philosophical sense, this is where I began. And as far as the other part of the title of our discussion is, I do employ Creative Commons for my work. And the work that I mainly produce is through Creative Migration. So we're a nonprofit organization based in the United States and in Thailand. And you know, I can also show you some examples, but one thing with our video work that we do is we primarily publish it through Vimeo, which I think is more creator friendly than, say, YouTube. YouTube gets more distribution, but I think Vimeo offers more protections and also is a nicer show place for work. And I'm able to add a Creative Commons license within the work very easily through Vimeo. And I have a whole sort of journey, a visual journey that I'm going to take you guys on a little later, showing examples. And I particularly often use the, hold on, I don't remember them all off the top of my head, so give me a chance to look. But as far as there's a distribution tool, and I typically use attribution, non-commercial, no derivatives, which is sort of the strongest protection that Creative Commons gives, where it's like, yes, you can show the work again, but you have to give us credit and you cannot change the work that is protected, is basically in layman's terms. And it really depends on, there are other artists that are producing so much work, they don't really care. And I have an example of that later, where they literally just want their name on it. And then there's also a choice within Vimeo, you can make it public domain or put no license at all. And so I think it just depends on what the work is, how protective you are of it. And also I'll show you an example. I'll show you part of a film a little bit later, but that also, I have the trailer, the teaser, different video clips of the film, but the film itself is not online. The film itself I've only showed in screenings or at museums and installations. And that's a way of protecting the entire intellectual property by not making the whole film available online, but only parts of it. And so it really depends upon what you're comfortable with and how much you want it out into the world, and what kind of distribution platform that you do have, if that makes sense.
Certainly, thank you.
Thank you so much, Susanna, for that comprehensive answer. And so if I may move over to Tiran, could you please tell us who is the owner of a copyrighted work in the case of employment? I think this is a question that's important for practitioners, and a lot of us are employed within an organization, an institution, an agency. And in that case, is it the employer who's the owner of the copyrighted work, or the employee?
Thank you so much, Linan. That's a very important issue to understand. And you have to understand that this is a very interesting part. Each country has a very different assumption on who owns what, who is the owner of copyright in the employer-employee relationship. For example, in Thailand, that I'm based here, the law said that if you are employee of the company, when you created work as part of your employment, then the employee, I, will be the copyright owner of the work. The company who employ me will have the right to use my work per the employment agreement that they have. But the copyright will belong to the employee. However, if it's a different type of work, let's say it's a commission work, then the employer who commissioned the work for the contractor to do it, the copyright owner is the one who paid money, the employer. So that's the general default in Thai law. But this is different in each country. For example, in Philippines, if I think in Philippines, if the employee is under the employment employee contractual agreement, then the employer will own the copyright. So, like I said, it's different in each country. However, in most of the country, I would say in all the country, you can state that in the contract on who owns what, then the contract will trump the default assumption of the law. That way, you have a clear idea on who owns what. The other thing that you need to understand that when we said employer-employee, so what is the law differentiate between commission and employer-employee relationship? What's the difference between this type of employment or hiring, work for hire, whatever? The difference is that for employer-employee relationship, the employer need to be able to have a certain control. For example, I need to be able to control when my employee gonna come to work, 8 to 5, 9 to 5. I have to have a certain control on, okay, if you do well, I'm gonna promote you to this position and that position. So they have to have a certain control of the advancement and how the employee do their work. However, in the commission of work, the employer should not have a control on when the workers going to do. Let's say, if I say that I'm gonna produce this sculpture, I'm gonna deliver it to you in 6 months. Between that 6 months, I might wake up at noon doing my work from 1 to 5 and go back to sleep. But the other day I might do it at 5 a.m. So the workers, the artists in this case, will be the one who control the time of their work. But the key is that when 6 months come, I should be able to deliver the product. So that's a general difference between commission work and the employee-employee work. And that's how the law will define in each jurisdiction on if this is the commission work, then the default of the law will be to this person. If it's the employer-employee, the default of the law will be that corporate owner will own that. But like I said, I would highly recommend you to put it in writing. So that's not going to be any gray area later on. So that's more fine point in the employer-employee relationship also, but I would not dive into that too deep. And I would recommend you to hire a lawyer in your jurisdiction to go into that detail, but just to give you the general idea on how it works.
Thank you, Terry. Preferably, I suppose at the start of a relationship between employer and employee, maybe that should be brought up as well, whether it should be included in the contract, the employment contract.
Yeah, and as an artist, I would recommend you to actually put that, because a lot of time people has a different assumption, and that is a general thing that happen when you have a discussion and said, I'm going to do this and that. And for a lot of the country, this kind of relationship might not need to be in writing to be able to enforce. But if you don't put it in writing, that tends to be misunderstanding between.
Right. And as you mentioned, I think our viewers should, if you are interested, you should really look at your national laws, because each country's national laws contain exceptions, and we can't really say now what those exceptions are. So there's no conformity. You really need to look into your individual national laws of copyright. Now, the phrase trace and contact has been trending throughout the year. Tracing and contacting. Susanna, tracing and contacting copyright owners can sometimes be difficult. How do you identify and contact the copyright owner or holder that you want to use their work?
Sure. So primarily the most content that I have copyrighted or have used within work is film content where I've used music, because music is a very, very essential part in filmmaking, and it really can sort of make or break the narrative. So I usually I listen to music constantly, and I usually, if there is a band that I like, and these aren't very big bands, I will write them and say, hey, I really like your music. This is the film project that we're doing. We are a nonprofit organization. We do not have a budget for licensing music. We would like to get your permission. And usually, especially these smaller musical artists, they are okay with showing or allowing us to use their work. I get in a good rapport with them. I provide them with a music license agreement, and I can share my screen. Hang on one second. I'll show you. And I'm happy to share this sort of template. So here are the terms: internet, screenings, credit, representation warranties, responsible for the website, entire agreement. So this is what I've used in the past. And that way there isn't any sort of confusion. Everything is very clear, and we're allowed to use the work for the film as long as it's around. And I will show you. So here's another example. Let's see, hold on one second. I have a lot of windows open to show you all. So we have our film soundtracks on SoundCloud, and you can see all 10 tracks here, and we only have 5 here. Actually, one got taken down where I have to find the contract to let them know I have permission and get it back up. But what especially this particular song has gotten a lot of hits, almost like 100,000. And the reason that they are still up there is because anytime SoundCloud says, hey, we've taken this song down, it's because you don't have the copyright, I then show them the music license agreement, send them a copy, and then it's back up on here. And so this is a way that not only can we offer the film soundtracks on SoundCloud, but I also can still use them within the film itself. So that is one way where I have contacted artists directly. And usually if they're smaller artists, they're pretty open to having their work shown. I'll give you like another more popular culture example. We are back at, can you see? So filmmaker Greta Gerwig, can you see this article?
Yeah.
Here. So for the film Lady Bird, they did not have a budget to license these very big songs from Justin Timberlake, Alanis Morissette, and Dave Matthews, and she wrote them very personal letters about what the music meant to them, meant to her, and why it would work in the film. And she got basically permission to use all 3 of these songs. And this is another way to do it. Is if usually artist to artist, people are pretty receptive to using the work if you are honest and transparent and straightforward in your approach. And so that's just another example. Even Justin Timberlake sometimes lets his music for use for free. So that's one way that just don't even feel apprehensive, especially about just a smaller artist, contacting them to see if you can use their work. The worst thing for an artist is to find their work being used without permission, because it feels like a violation. It's just like if somebody broke into your car and stole whatever's in the car out. You know, it's a violation. But if you ask permission, you are very straightforward and you're organized. Usually, for the most part, I've gotten, I don't know, in the ballpark of like maybe 90% yeses. So it's definitely, I highly suggest going that route if there is a particular work that you know you'd like to use.
Thank you so much, Susanna. You actually answered one of the questions that one of our viewers had from Cambodia, because his question was, as a performer, so he's a performing artist, a dancer, and he was asking if he could use music from YouTube to choreograph his work, would it be considered a violation? And I think you really touched on something important about communication, just contacting people. And people actually are usually happy to share their work. It usually gives them exposure, and just open those lines and credit them. And, you know, it's a good opportunity for collaboration. So thank you so much for addressing that.
Actually, I have a question for Susanna. When you said you reach out to the artist directly, on the music side, sometimes in many countries they have what they call collective management organization, the SEAMEOs, who's like a central association to dealing with the licensing of music. Normally, do you work with them at all, or do you think that it would be better to reach out directly to the artists themselves?
Most of the artists that I've worked with are quite small, so they were representing themselves. But with some of the other artists that are a little bigger, I dealt directly with their record label. So then the record label or, you know, who also deals with the publishing, they dealt with the permissions for me and asked the band directly, can we use this music for this? And then the band answers back, and then I negotiate with the record label themselves. And so I have not dealt with very big artists, but also I did work in the music industry. So I know a lot of people at a lot of different record labels, and I know a lot of artists. So some people I knew already, and I would just ask them. But I'm particularly showing you an example of people that I didn't know, where I just really liked the work, and they let me use it. Also, it's nice to, if you have friends or acquaintances that you know, that's usually an easier route as well. But I wouldn't shy away from somebody you don't know who might be halfway around the world, but you like the music. It's still a possibility.
Yeah, because I want to touch on that because especially in Thailand, I would say there's a lot of problem of in Thailand. I have to say this first. In many countries, copyright is normally protected under the civil law. In Thailand, we heavily use criminal. It is a criminal offense. So if you use your the music without the permission, that's criminal offense for you. So that's quite serious. So in Thailand, especially, I would say that you want to be on the safe side in using the music. So, and I know that it can be very hard to track down on, let's say, I want to use the music from this popular artist, but I don't know how to personally reach out to him. One of the source that you can ask permission for the music is SEAMEO, Collective Management Society organization. However, I have to tell you that normally it's not free. You need to be in a very specific situation that you can ask him for free, but at least these are the people that you need, you want to be in touch with, or else it would be, we don't want to get a notice to you that you break this law and then we're going to bring you to jail. So yeah, just I want to take note on that.
Taryn, in that context, are you aware of a central music copyright registry in Thailand?
Well, like I said, it's not required to register your copyrighted work, and the collective management organization in most of the country is pretty centralized. Let's say in the US, you have people like the organization like IFPI or those kind of guys that you can just one stop and then ask for permission, and then they have a certain rate for certain thing that you're gonna use the music for. However, in Thailand, we have one of the most quantity in the number of CMOs in Thailand. I think we have like 38. So it can be very confusing on who's you're gonna get the music from. But if it's like international music from big records, there's several company like I think MPC. I think you can Google it, MPC Thailand. They have a lot of record companies as their association, but I don't have the information on the top of my head now on who owns what. But that's the thing that I just want you to be caution when using music. You can do it, but you, like Leon said, communication is important. You want to get the permission before you use it.
Well, and I also used to work at a couple different labels. One of them was Capitol Records, and I remember the lawyer would just chat. He's like, I gotta go now, go after this person who put this thing on eBay and get them to take it down because they're not allowed to. And so they have active legal departments that are searching and finding and protecting the artists that they represent. So it can be quite litigious, especially for the larger artists, but it just is also thinking about, as a content creator yourself, if you're making something out of respect for the other artists, especially if they're a smaller artist who doesn't have all those protections. I really try and you know, it's an ethical question as well. Is I wouldn't want somebody to use my work in a way that I didn't want, and so the same thing. I always try and really be clear and transparent with the artist and not use somebody's work in a deceptive way when they don't know, because it's also it's a violation. So thinking back about the moral ethics, if you're always thinking about the other person and how they would feel with their work being misinterpreted, then it's another sort of safety net too. Aside from like legally, it's like a sort of an artist code of ethics as well.
So yeah, thank you, Susanna. So we've talked a lot about limitations and violations, and I think a lot of our viewers, it's actually been posed as a question now. What are the exceptions when copyrighted works can be used in the context of, like, for example, education museums? Maybe Tira and Susanna, if you could chime in on that, that would be great, because a lot of people would need to use copyrighted works in certain instances. So what would those instances be?
Right. Susan, you want to go ahead, or you want me to do it?
Sure, I can start. So one of my favorite tools that I always use is Creative Commons. And I can show some visual examples of first, I'll show a search and how I got a piece of music. And then I can also show you a film segment that also utilizes Creative Commons. So I will share the screen. And we will start back. So this is Creative Commons. And this is the search, so search for content to reuse. And you can also click if I want to use something commercially or to modify and adapt. So I'm recreating an actual search that I did a couple months ago. So we were putting together a teaser for, we're partnering with the 60-Second Film Festival in Bangkok, and we are implementing sustainable filmmaking practices within the festival. And so this is sort of a new addition that we're promoting. And Oliver, who is runs 60 Second, he put together a really great video, but the music didn't quite fit the content and the feel that we wanted. So I went on Creative Commons, and I just, I wanted something sort of slower and more, didn't feel like it was so much in a club, basically. And so I just typed in, ambient, and I did a search. And then I went to audio. And then honestly, I'll just save you guys a lot of headache. Wikimedia Commons is probably the best one to go to for the most content. So then I already have that open. So I went here, ambient, and you see all these files that you can start listening to, including like tracks from Moby, who's a very big artist who's offering his music for free. And then I will show you, this is one track from Moby. You can see, you can download it. You can use this file on the web. This work has been released into public domain. This applies worldwide. Moby grants the right, anyone the right to use this work for any purpose without any conditions unless such conditions are required by law. This, I think, Tareen, we're gonna have to get your feedback on.
Sure. All right. Well, in general, let me step back a little bit. When I mentioned in my PowerPoint that the right owner will have the exclusive right to reproduce, show it to the public, make adaptation. However, there's a certain thing that you can do. Well, if you want to use the thing, if you want to do the thing that is the exclusive right of the copyright owner, you have two ways to do it. Either first, normally get permission, or if they are already provided to be public domain, like this is. The other way to do it without having to ask for their specific permission is what we call fair use or fair dealing in many countries. What is fair use? Fair use is sometimes the concept of copyright protection is to protect the creator, so encourage them to create new things, to bring on new creative ideas. However, if you not allow them to do anything, that might counterproductive in the creativity in general. So sometimes you can do something that is the exclusive right of the copyright owner. However, in order to do that, it needs to meet a very certain, the law normally require things that you can do it and consider fair use. For example, doing it in the educational kind of way, doing it for research. However, the key part is normally you should not do it for commercial purpose. And it should not affect how the creator normally do their business. So even you do it for the educational purpose, but in effect, it makes the creator of such work and no longer use that particular work commercially, then it's not considered fair use. So in general, it depends on what you're gonna do with that work, and would that affect how the creator do their business. And it's also have a very, fair use is what we lawyers don't like to say in general, because it's in a very gray area. There's no finite line on what is considered fair use. For example, in you may say that I only use 5% of the work. Would that be fair use? The answer is yes and no. You might use just 5%, and it might not. It depends on whether that will impact how the original owner of that copyrighted work will use his work. For example, if I use 5%, but that 5% is the key part of that particular work, that might not be fair use. And each country, each jurisdiction has a different line of what is considered fair use. So in order to consider fair use, the general rule, just the general, is that you use it in the purpose that is not commercially purpose, and it's not affect how the original copyright owner will do that to commercialize their work. That's the general rule, but each country has a different. Yeah.
Can I ask you a question? Sure. So with this one, it says use this work for any purpose. If I was a car company and I wanted to use this song for a commercial, would I be able to do that?
I would say if the copyright owner said for this particular thing, if it said for any purpose, I'm just going to apply the Thai law here. I would say that it should be okay.
Okay.
Yeah, to use it commercially. Yeah.
So thank you, Tiran. You did mention education, and I think that's a lot of our viewers here today are lecturers, students, scholars, and delivering presentations are a part of their day-to-day work. And a lot of our viewers also work in museums today. So could you please give us a bit more on that, on what can be used for educational purposes, what can be used from artworks in museums and all of that? That would be great. Thank you.
Sure. When you said educational, it can be tricky. Let's just say in Thailand, there's so many, what they call extra school for students to take class after the normal school, let's say on weekends. Those extra school will charge your parents sometimes a very hefty fee. So in that case, although it's in the educational sense, it can still be on the commercial purpose. And if you use the work of others, of copyrighted work without getting their permission, that might be considered a reproduction of their work, and then it's copyright violation in that sense. So even if it's educational work, you teach in the school, it still have to go back to the general rule that is for not non-commercial purpose, and it's not impact how the copyright owner make their living. So that's the ground rule. Even for educational purpose, you cannot break that ground rule. So if you want to use it, just to be safe, you should get the permission. I know that's not what people want to hear, but that's the law.
And there are educational rates, and sometimes nonprofit or educational, not rate, but you get to use it for free. Whereas like even I've looked into screening certain documentaries or films, and sometimes they're free or discounted rate versus if I was a cinema and I wanted to play a film. So I think it takes some research, but there are different options, and always like I've gotten very good as a nonprofit. I always ask like, is there a nonprofit rate? Is there something for free? Is there an educational purpose? We are non-commercial. We're not charging any tickets. This is what we're doing. And a lot of the times there is no charge.
And yeah, I think Susanna mentioned a good point. When you use other people's stuff on your work, even if it's for educational, normally there's and I think that's where Creative Commons plays a big role. So if you want to get one thing, they might not be the sole source of that particular thing that you want to use. There are other legitimate source that you might be able to get it without having to pay anything. You might need to give them credits, but even that sometimes it's not allowed. It's not required. So I think that's why Creative Commons plays a big role. That you may use the other people's work without having to go through the hassle of who I have to get the permission from and those kind of thing, and it's still legal.
Yeah. I'm going to finish showing the how I found song and putting it in just to give. So I'm going to go back to the search. So here we are. So here I'm back at ambient. The Moby song actually didn't work out, so it didn't match. So I kept looking, and then I found another artist, Chris Zabriskie, and so I played this and liked it. So then I went on to his, wait, I'm going to show you maybe, hold on, more of the search. So then I clicked on this, and then I clicked on Bandcamp. And then I went and I listened to a bunch of tracks. And then I found one that I liked. And then I went on his website. And there's a whole licensing section. And he's using Creative Commons License 4.0. And he basically said, for most projects, crediting me can be as simple as music by Chris Zabriskie. So I will show you now an example. I don't know how to toggle, so I'm going to stop sharing and go back again to of the promo that we made with his music. Okay, can you guys see?
Yeah.
Okay, hopefully you can hear. And it's as simple as that. Luckily, the video, we didn't even need to re-edit at all. It's just like the music matched the cuts quite well. And this is what we simply put at the end. And we haven't, we've only been using this internally, but when we do start promoting, I already will connect all his social media and promote it out and contact him and just make sure that he knows that we're using it on a public level. And that's a strong example of searching on Creative Commons. I have a couple more, but we can go back and forth. You guys let me know what we should do next.
Oh no, thank you very much for showing us the tools. I think like the way you showed how you search for a piece is really important. And I'd like our viewers to know, so you can, as Susanna showed, you can search for a picture, an illustration, video, and audio. And there are also resources, you can also find educational resources and books, but we can talk more about that later. I'd also like to share a comment that we have from Zoom. I'm assuming that he or she works in a museum and would like to share with the rest of our viewers that many museums allow pictures of artifacts in their collection to be used for educational purposes. And you just need to fill out a form on their website to do so. They actually have a dedicated part that you can just type in what you're using it for, and so that you can be granted permission. So here's also another tool that you can use for educational purposes contributed by one of our viewers. So thank you for that.
So I have a question for that comment. So if I want to use it for commercial purpose, who should I get permission from the museum? And is there going to be fee involved?
From my own experience, sometimes just out of curiosity, going into museum websites that offer resources on a limited basis, they have a section which allows you to read the fine lines of what those resources can or cannot be used for what purposes. So yeah, we need to do some legwork if we need to get free resources. But it's a huge collection that a few museums have offered to users to use for free. And I was going to go into that. For example, the Metropolitan Museum of Art, the Smithsonian Institute, just to mention a few, they have opened a large part of their collections for public to access and to even download and use. But you need to read the permissions and how you can and cannot use them.
Thank you, Ian.
May I show another example of footage and how to credit it? So this will be a short clip. This is film Post New Bills that we made, and this film is not available online in its entirety, only parts. And I have a sequence I'm going to show you that's all Creative Commons footage. So here we go.
Meanwhile, we're having record level storm damage, record level flooding, record level droughts, fire. What more can you say? You know, it's just, it's here. Radical changes of weather patterns are going to be affecting a lot of people. So the arts are something that help people understand that, and they're kind of shock absorbers, you know.
I think that when it comes.
So that's the sequence. And then at the end for our credits, okay, hold on here. Hang on. Okay, so you see, this is how we credited the musicians, and then this is Creative Commons. So this is the additional footage. We got most of it from YouTube, and this is how the name of each video and the credit. And this is all through a Creative Commons search. And furthermore, just to let everyone know that NASA, public domain, image and videos. So anything that you would like to use from outer space is provided by NASA, which is great. Images, videos, and audio. And this is something that we used for another project. This is just a short teaser that I'll show you. And all of that was from NASA. It looks impressive, and it was all for free. Yeah. So that's another way. And then one last example, if you go into the settings of Creative Commons, of Vimeo, and you want to put a license, this is right under distribution, and you can put no Creative Commons, all of them, or public domain. And so we always put the strongest one on ours, but this is a very easy way to protect your work.
Suzette, I don't know if it's just me, but my view is still on the additional footage NASA page. I didn't actually see.
Oh no, really?
Yeah.
Okay.
That could have been just.
Yeah, same for me.
Okay.
Okay, hold on. Are we still here? Hold on,
Yeah.
I'm gonna shoot. Okay, here. So I played that video without you seeing anything. Okay, well, can you see now?
Yeah, there
Yes.
we go.
Yes.
Okay. So in the back end of Vimeo, under distribution, you scroll down and there's the Creative Commons license. And so you can choose how you'd like to protect your work, which is why I really like Vimeo. And then I'll just show you quickly the video that you didn't get a chance to see. You just heard it.
Thank you.
But this is all the footage from NASA. This is no way that we could have gotten this, or the artist could have gotten all this. So again, this is what I really like about Vimeo. This is what's great about NASA. And then can you see this, or is it, yes?
Yeah, yeah.
Yeah, and so this is, like when you go on Creative Commons, this is how you can, an example of a license. And it explains exactly, everything that goes into it, and you can change that. And you can even, it showed on Vimeo, I could change what the license is today if I wanted to, from what it was before.
Yeah,
and I
the
usually
website.
once I pick it, I stick with it. But I don't know, maybe that's, we'll get the lawyer's expert opinion on that. But I usually just always go with the strongest one.
And the Creative Commons website is very helpful. It provides step-by-step guidelines on what kind of license you want to choose. And then it takes you step by step on how to apply for your license and obtain it, including it also provides you guidance on how to attribute your sources as well.
Yeah, so thank you very much for sharing those valuable tools, those images from NASA, and also how you can protect your work on a platform like Vimeo. I certainly learned a lot just now that I could use for my everyday work. Another tip shared by a viewer today, and which actually responds to what Tieran was asking, is that the Rijksmuseum in Amsterdam allows you to use their images even for commercial purposes for free, as they consider it the best advertising they can get. And they even host annual awards for the best commercial use of their images. And this user says that it has inspired other museums to rethink their roles. So again, a lot of legal information is available on their website, and you could always check or always just ask. As Susanna pointed out, communication is key. So,
yeah, I'm looking at the comment, and the conclusion to it is the key, in fact, to our discussion is when this commentator or this contributor posted this, she or he ended it with, we need to rethink our role, which is to share and educate. And I think free licenses and Creative Commons help us in a big way. And I think also we mentioned a few times about public domain, and I guess maybe we should touch on it a little bit for audience who are wondering, what are they talking about? What public domains? Is this something completely free that we can use? And it's true, public domain is an repository or somewhere in the cloud or on the internet where you could access works and resources which have so-called run out of their copyright date, meaning their works have expired in terms of copyright protection, and they are free to use, and there are plenty of them on the internet which are public domain.
Yeah, I think you talk pretty clearly on the public domain. So I just want to add that in general, like I said, there's a lot of intellectual property protection, trademark, patent, copyright. Each of them has a certain term because intellectual property in itself is the monopoly right for the creator, the inventors to reap the rewards of their labor. But since it has a protection, it has a certain term. So once that term runs out, it will become public domain. So people can use it freely. So let's say for copyright, like Ian said, in many countries, it's 50 years after the other state. In the US might be, or in the EU might be longer, 70 years. So once that work runs out of a protection term, you can use it. The tricky part is how to know whether that work is in the public domain in itself. For that, you probably need to do some research to make sure that that work is actually in the public domain.
Also, in addition to that, the Creative Commons allow a user or a creator to choose to make your work a public domain, even though the copyright protection still exists and you still have copyright ownership. You can choose to make it free, so you assign it to public domain by using what they call the public domain or the Creative Commons 0. They call it 0, and that becomes a kind of a public domain. So yeah, I think understanding copyright and what the Creative Commons can do for art and science contribute to equitable and accessible education. As Susanna says, sharing academic and artistic resources enables the global community to collaborate and innovate, particularly if you look at the amount of digital content widely available and used today. And it's not just the academic, medical, scientific fields that benefit from it, but also other professions and industries. Consider platforms such as the open access journals, and Wikipedia, which is completely Creative Commons, and then, correct me if I'm wrong somewhere, and then Vimeo that Susanna mentioned. They have been using the Creative Commons licenses for sharing content for a long time. And at this moment, like 1.6 billion videos, photos, music, scientific research, etc., apply the Creative Commons licenses.
And I'd also like to add, like, there's a whole philosophy behind a lot of creators about really the democratization of the internet and trying to, in its purest sense, like sharing each other with creative work, ideas, and really sharing that ethos. And there's even a filmmaker in the UK, Adam Curtis, who makes a lot of documentary films. He's a BBC archivist, and so he uses a lot of that footage within his filmmaking. He allows all of his films on YouTube for free to watch in its entirety. You can screen them, you can watch them. He doesn't care. And he also uses really good music, but he was able to access it through his job at the BBC. So there's really a sense of like trying to keep things in this open source ethos in order to not have things so controlled. And I think that with a lot of creators, they want to keep that open and allow like the best of people to come through. And for us to share in this sort of purest way. I know it doesn't always work, but it is something that we all strive for to some degree. I really enjoy using open source platforms and open source education, like doing like MOOCs and everything else, because I think it's a way to share knowledge and to sort of like build upon being a more enlightened society. And I think that is something that we should all think about as well.
Yeah, you are the ideal advocate for open resources, and we're glad to have you on this program. There is a query from a work colleague, so I want to pop this in before we run out of time. It's about what if an artist or craftsmaker, entrepreneur created figurines, say of the Singapore Malayan sculpture, for example, and sold them online. Would this be not only ethically questionable, but would this be a copyright violation?
I mean, the create a figurine of the copyrighted work is it can be adaptation of the work. So I would be very cautious in create a reproduction in adapting the copyrighted work. I am not sure whether the Merlion itself, I don't have history. Maybe Ian, you might.
Well, I took the opportunity to look up Wikipedia, and the Merlion is a registered mark of the Singapore Tourism Board and is copyright protected. So
Okay.
I think it's very clear that they mentioned that imagery of the Merlion should be avoided in commercial use content, provided it appears in context and it's not the sole focus of, say, the imagery or content featuring the Merlion that may be suitable for editorial use. Apart from that,
yeah, and each country has a very has their own interpretation of the law. Fun fact, you know that if you take a picture of a Eiffel Tower in the night, that is actually a copyright infringement under the French law.
yeah.
Because I've actually heard that as a very, very famous example.
Yes.
And so now we're getting into things where, you know, there are fine lines.
Yeah.
And a lot of our viewers and a lot of our stakeholders at SEAMEO SPAFA actually work in, you know, the conservation of traditional arts, which would of course involve traditional designs and motifs, which often get reproduced on a massive scale or by, you know, high-end luxury brands and sold at a very high price. What are the limitations on that in terms of using these traditional designs?
There's no, I would say if the original, if you create the new design based on what is the original lead, normally copyright will protect original design. I'm going to start with that. So if it's something that already exists under copyright law, you might not get clear protection on that, but that's dependent on the jurisdiction also. But if you are in the arts and craft business, you create the new thing that might based on the thing that might be on the public domain or is traditionally the new thing that you create. You have a copyright. It is your copyright on the new design, and if someone else copy that particular design that you inspire by your traditional folklore, for example, then it's a copyright violation. But to copy the design of the things that already exist in for hundreds of years, that might not be copyright protected.
So yeah, so I guess this is where you hear the uproar of, you know, cultural appropriation and all of that. And here we go back again to crediting. So even if it's not a violation, even if it now belongs to the public domain, I think we can all agree from an ethical perspective that it never hurts to credit the origins of where you've taken your inspiration from. Like, it has come from these people who live in this part of the world, and, you know, just to, you know, show your appreciation for these cultures.
Yeah, it's the community spirit. You know, if we share our work, we should take it upon us to also recognize our fellows creators. And
you have to understand that copyright law is not the only law that protect this kind of thing. They might, in each country, they might have their what we call sui generis, the specific law that protect a certain kind, that provide additional protection. So it will depend on each country law that they might have additional protection that might not be under the copyright law also. So you need to be aware of that too.
Terry, I earlier saw a question posted by the public viewing this discussion on plagiarism. I think it was about whether there's any difference between plagiarism and copyright infringement.
Yeah, slightly different actually. Copyright protect, like I said, copyright protect the expression of ideas. Plagiarism, correct me if I'm wrong, I'm not a very good at the words, but plagiarism, I understand that is you claim others people's idea and then you say that it is your own ideas. Right. So if what you claim doesn't meet, let's say it doesn't meet originality level, or it's just very common things, it might be plagiarism, but it might not be copyright infringement. If the work is meet the certain level to be considered a copyrighted work, and then you copy it, that's copyright infringement, and it's a violation of law if you commit that. plagiarism might not, if the work that you claim on your own is not considered copyrighted work, it might not be violation. And you may be able to do that, although it's wrong, it might not be against the law, so to speak.
Thank you. I think the important key is not giving proper credit.
Mm-hmm.
I think whatever amount you use, you should get permission. And if you don't, then if it's not a large amount, you give credit, and that should be allowed.
Mm-hmm.
And so, for example, how would a platform like Creative Commons or like tools like Creative Commons licenses address issues like plagiarism?
Susan, I'm not a very good Creative Commons expert.
I have no idea.
I think
I always think people's work on Creative Commons is original, but I don't know. I guess that does happen.
Yeah, I think while the Creative Commons is a powerful tool for dealing with copyright, it does not address issues of citation and plagiarism. The CC license works may be used in a manner that is legal under the license, but plagiarism may still be considered to have been committed.
Yeah, and one thing I want to add that I forgot to add, when you say citation, if it is, if you're using other people's copyrighted work without permission, even if you provide citation given to the credit, that's still copyright infringement. You have to be aware of that. It's not like you said, I'm using this person, but hey, I give you credit. What more do you want?
No, good point.
Yeah.
Yeah.
If you not get permission, it's like, yeah, it's a problem.
Yeah. For example, you pasted a large amount of Creative Commons license text into your work, but you did not quote it or give attribution. There's no violation under Creative Commons license, but because there's no proper attribution, your article or your work does not comply with the academic standard already.
And Susan, I understand that Creative Commons have a lot of things that you can click on that you want to do this and that. So I think it's you cannot just say that it is Creative Commons, I can do whatever you want with it. You need to look at what type of authorization that the owner of that work allow you to do. Is that correct, Susan?
Exactly. Exactly. And particularly with the example of the film I showed, we narrowed down the footage that we would use based on the license and how we could use it. So it wasn't, there were other, I remember the film was made a while ago, but I remember there was other footage we wanted to use and it was too complicated. So we said, forget it. We're just going to use what we are certain of. But yeah, you have to look at the fine print. So just like I showed the Chris Zabreski's website, we basically credited him how he said on the website because it was a 30-second promo for, you know, a nonprofit initiative. But if it was something bigger, I would look more into putting the Creative Commons license on the work. I think it just, but you have to really look at each example because not all of them are the same.
Yeah, and for viewers, I think the Creative Commons website would be very helpful. And I'm wondering, before we run out of time, just to give a glimpse, if I could share with users this. Do you see the screen?
Yes.
Yep.
Yeah. So these are the various types of licenses that users could choose to apply to their copyright work, and then allowed other users to use them in the way they choose for the users to use or reuse and distribute. Basically, you have the requiring the users to attribute with the top one, which is BY, and then no derivative works for those who would not like their users to edit or modify their creations. And the third one is the share alike, which dictates that if you use a work that uses the license share alike, when you create a license for your work based on that other work, you should also apply a share alike for your license. And the last one is non-commercial. Basically, you do not allow users to copy, distribute, display for non-commercial purposes. But there are 6 major licenses under Creative Commons. These are the 4 types which are used in conjunction with one another. Well, I hope that gives viewers a glimpse into it. They should go into the Creative Commons website and learn more about how they can apply for a Creative Commons license.
Thank you so much for sharing that, Ian. And maybe we could address some scenarios or that would happen in our day-to-day work in using content. So if I could ask this question to our panelists, if someone makes a painting or an illustration based on a photograph, is the copyright considered as violated?
Someone make a painting of the, and you're still showing your screen, just so you know.
Wait, stop sharing.
All right, so excuse me. The question was if I'm create a painting from the photograph, is that copyright infringement? Is that the question? Sorry, Linan.
Copyright infringement, because actually, amongst our stakeholders, a lot of them are artists. So there could be a case where, for example, they make a painting or an illustration based on a photograph.
I mean, like I said, you have to look at your national law also, but in general, by making a painting out of the photograph that is still, let's say the photographer is still alive, for example, it's not in the public domain yet. That for most of the jurisdiction, that's still considered adaptation of the copyrighted work. And you need to get the permission. If you get the permission, the painting that you create is your own copyrighted work. You will get protection for that painting. The original work, the picture itself is still the copyright still belong to the original, the photographer. However, if you will not get the permission, that can be copyright violation, unless it falls under fair use, which is, like I said, a tricky part. You have to prove that it is fair use.
Thank you so much, Chair, for answering that. Yes, Ian.
Yeah, I mean, if we are based in Southeast Asia, I guess a lot of our viewers might be interested to know about copyright in the region. And one thing that we haven't really touched on is how long does the copyright protect the works of a creator? And I believed, if I'm mistaken, tell me, Taryn, that generally in Southeast Asia, it covers the lifetime of the owner plus a certain number of years. And normally it's 50 years for a lot of countries in Southeast Asia, right?
Yeah.
After the death of the owner.
Yes.
Singapore being the exception. I think Singapore is lifetime plus 70 years.
Yeah.
Yeah, and I want to get that out because users might be interested to know how long do these copyright last.
And I think the good source of this information is in each country in Southeast Asia, you have a pretty robust IP department, intellectual property office. So most of this information you can find out in the on the Intellectual Property Office website. Normally it's DIP, Department of Intellectual Property. So they will have a pretty good general information. So yeah, I would highly recommend you to check the one in your country out.
Right.
Mm-hmm.
So quickly, Tarin, if I pay someone to create something for me, which is commission work,
Mm-hmm.
I own the copyright, right?
In Thailand, yes. I would say in most of the country, yes. But like I say, I have to disclaim that some of the country might have a different assumption, but in most of the country, yes.
Yeah.
Mm-hmm.
Okay, we I guess the conclusion, one of the conclusions is that creators should consider the priority of using permissible works such as public domain works, Creative Commons licensed works that are given free licenses. And we will be providing after this event a summary of our discussions that would include the sources to locate educational and creative resources. I think with copyright matters, most of us take the approach of we cross the bridge when we get there. It's only when we are confronted with an issue do we try to find out what copyright is about. And like air flight safety precautions, I think it's better to know them before an incident rather than, Again, we stress that information in this conversation should not be interpreted as legal advice. What we attempt to do is to increase awareness and appreciation of the need to understand a bit more about copyright and the Creative Commons. We like to think that the audience and ourselves have picked up one or two things that can pass off as new knowledge, and that we may now be more interested in learning more on the internet. From many copyright and intellectual property content online and blogs, there are plenty of blogs, as well as the official Creative Commons website and FAQs pages, which are abundant. This is when
I also, could I add one
Yeah.
last thing? For the music that we put into the promo video, it took me about 2 to 3 hours to find the replacement music through Creative Commons because we needed to do it fast. And so it does work. It is a good resource, and it doesn't also have to take a lot of time.
Oh yeah, 2 to 3 hours.
Yeah.
That's pretty snappy.
I have a lot of experience doing it, so I think that also played into account, but it's still, I was able to find a replacement music within a pinch.
Yeah, maybe there's a need to do a workshop to train one another how to make use of these resources. And this is when I take the cue to promote OERs, the Open Educational Resources. These are learning, teaching, and research materials in any format and medium. And they can be found in the public domain or under copyright, but released under an open license. For example, the Creative Commons, that allows no-cost access, reuse, repurpose, adaptation, and redistribution. And SEAMEO, which we are a part of, is very much in this OER movement. And for viewers, information, there is a dynamic collision. It's actually called dynamic collision at the forefront of such a movement, and it's made up of the OER Foundation, along with UNESCO and the International Council for Open and Distance Education. You could do a search on dynamic collision and you will get more information. If your interest is sparked, you should search to find out more about this online course on copyright and open licensing. It's called Open Education, Copyright and Open Licensing in a Digital World. This is available on the OER Foundation website. I will include these references in the summary after this discussion. Well, we've taken 2 hours, no wait, 1 hour and 45 minutes. Tareen or Susanna, do you have any essential parts that you thought we have dropped that should be included before we start to wind down?
Not right now, but if there's additional question, I'm happy to ask it later on. I can give, you can ask Ian and then he email me and try to answer, I guess.
Actually, maybe if I may really quickly. So Ian just mentioned open educational resources that are available. So I'm just going to show an example of what we've produced here at SEAMEO SPAFA, a publication in collaboration with the Asia Pacific Center of Education for International Understanding, which is under the auspices of UNESCO. As Ian mentioned, they're quite a big contributor to open educational resource platforms. And so this is just an example of a publication, an educational resource. Can you see my screen here?
Yes.
This page?
Yeah.
Yeah. So you can see we've put copyright 2019 APSI and SEAMEO SPAFA, and we've put it under a Creative Commons license so that people can use it, show it. Yeah, and again, we feel that sharing this knowledge, and because this is a book on living with water heritage and risks, it's about indigenous knowledge. Again, it touches on sustainability and things like that people can use for education. That's just one example of what you can do in addition to audio, in addition to pictures and all of that. And we felt that putting this publication under Creative Commons license for it to be shared and reused is also a thank you to the photographs and the illustrations that we used from Creative Commons inside the educational resource as well. So yeah, so thank you for letting me show that. And so with that, if there are not any more questions or any more comments from Susanna and Tareen, I would like to thank you both for contributing to such a dynamic and vibrant discussion on today's SPAFA Sesh. And a big thank you to our viewers today who not only asked questions, but also gave us tips on resources that we can use.
And we still have a record of them, and I suppose we could communicate with them later so that we do not miss out.
Absolutely. So we also have records of them, so we can hunt down the winner of the tote bag, who I'm going to announce now. So from Facebook, our winner is Cecilia Ong. And from Zoom, it's Jonil de los Reyes from the Philippines. So we will be in contact with you individually to let you know how we can get these tote bags to you. Thank you for participating. We will also, so as Ian said, we're going to post a summary of this discussion on our website and on our Facebook very shortly. And he's going to provide a list of resources that people can consult to learn more about copyright and Creative Commons. We will also be posting an evaluation form so you can tell us what you thought about this SPAFA Sesh. And it would really be highly appreciated on our part because it really helps us to better serve our stakeholders in the region and beyond. Also, do not miss out on future SPAFA sessions by liking and following us on our Facebook page and signing up for our newsletter. You can also view recordings of today's session because they will be posted on our YouTube channel for posterity. So if you've missed anything and you want to go back to it, feel free to check us out on there, where we also have other videos related to the archaeology, arts, and culture of Southeast Asia. And you can subscribe to that too. So with that, thank you very much for joining us. Ian, anything else?
Yeah, I'd like to say thank you, Susanna and Tareen, for making the time and effort. We are deeply grateful to you for your valuable contributions. It was fun doing this with you, beautiful people, beautiful team, and also to Lina Arndt and our IT staff and others who set up this session. Thank you.
Oh, thank you. Thank you for having me. It is fun.
Yeah, I think there's so much to go into. We're just covering the tip of the iceberg, in fact. Maybe we can even do more in due course.
Sure.
Thank you, Susanna. Thank you, Tareen.
Thank you.
All right. Thank you.
Thank
See you
you
soon.
for joining us. Thank you.
Keep well, keep safe.